Garden State TM. 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 Garden State TM.
Joseph P. Rem Jr., can't forget that.
Cannot forget that.
Certified.
Or certifiable.
Certified. Not even regular. Certified criminal trial attorney.
That's me.
I don't want to hold you down to a firm number, Joseph, but how many jury trials do you think you've done in your 40-year career as a New Jersey attorney?
Well, it'd be hard to say, but, probably maybe 65, 70.
All right, so you bring a little bit to the table. And I'd like to discuss opening and closing statements today, but I really want to draw on your experience, as the practical aspects of it. But I also want to kind of tap into your experience as being a prosecutor as well as a defense attorney. Now, I know it's been a long time since you were a prosecutor, but by the same token, you had a whole bunch of jury trials when you were in the Passaic County Prosecutor's Office.
We did.
Fair to say?
Yeah, it was before PTI and before first and second degree sentencing and before mandatory minimums. So you had nothing to lose by going to trial. You could get 20 years in state prison or flat out probation, and the judge had the full authority to take you the full range. So you had very little to risk by going to trial.
Those are the good old days.
In fact, the very first time you were required to come to the courthouse was the day of trial. There were no calendar calls. You didn't even go for arraignment. You got mailed an arraignment package, you signed the form and mailed it back. So you never had to be in the courthouse on the case until your day of trial.
Let's kind of think back now, and I want to ask you some general questions. Again, these are just personal with you. Sometimes I hear attorneys say, I already know I know what my opening is going to be, and I know what my closing is going to be before any witnesses have testified at all. Is that you, or do you kind of keep things going till the last minute? How do you prepare?
Well, for the overwhelming majority of my cases, I've learned from sad experience, because only by sad experience do you get good experience. I've tried enough cases to know that I have no idea what the state's witnesses are going to say or what my witnesses, and the rare occasions when I have them, are going to say. You could prep a witness for 4 days, and then they're going to come out and do a 90-degree turn on you in the middle of it, and that frequently happens in cases. So in order to keep myself loose, there are many cases I've gone into with one theory of defense, and because the testimony was so dramatically different than what was in the police reports and in the witnesses' statements, we find ourselves going a completely different path. I like to leave myself room to change. If I give the jury my theory of defense in the opening, I'm locked into that, and I can't take advantage of the way the pattern by which the testimony actually diverts and digresses from the reports and the police statements.
What are you trying then to accomplish strategically in your opening statement, Joey?
Well, I try to let the jury know that the process by which my client was brought here was very unfair, and you focus on the grand jury. You say, listen, the prosecutor's there, the state's witnesses are all there, but there's no defense attorney. And no one cross-examines these people. And there's no one to bring out the defense case. And the defendant not only isn't there, he doesn't even know that it's going on. So give the jury a sense of, geez, this is a pretty unfair process, and this defendant has been treated unfairly. Now, you and I know that may not be true in reality, but certainly you give that illusion with that by saying that this is just the state decided to bring him here and didn't give him a chance to defend himself or tell his story in the process. Then you want to talk about how the deck is stacked in favor of your client. For instance, you want to tell them about proof beyond a reasonable doubt, and how if 50-50, we're talking about the scales of justice, but they have to be like this, because if it's like this and the jury convicts, then everyone in America would be convicted and there would be no criminality. This is the way we decide money issues. Liberty is certainly a much more important issue. I tell them about the fact that the burden of proof rests on the state, and I tell them it not only rests on the state throughout this entire trial, it rests on the state even while you are deliberating in the jury room. When you go into that jury room, you all have to to say, fold your arms and say, I presume that person to be innocent. While we're deliberating, now, has anyone here said anything to make me change my mind? I swore an oath to maintain this during these deliberations so that I don't even have a single reasonable doubt as to this person's guilt. So I try to move along lines such as that. And what I do in my opening is when I talk about the presumption of innocence, I'll go behind my client. If it's a man, I'll put my hands on his shoulders. If it's a woman, I'll stand behind her. So they see me standing close to this person. They know I'm not afraid of this person. You know, whether it's a crime of simple drugs or embezzlement, that's one thing, but sometimes it's a crime of violence, people with weapons, people doing acts of violence. And they'll see me standing by them and they'll think, well, he's not afraid of this person. And he has his hands on his shoulders. There's a bond here. We trust Mr. Ram. He's not violent. He appears to be low-key. He appears to be honorable and ethical. And he's vouching for this person. Inferentially, I am certainly not overtly and not vocally, but inferentially I'm doing that to let the jury know that I associate with this person. So I try to put him in the best possible light. I tell the jury not to make up their mind as the evidence is coming in. I said, because, and the way I analogize, I say, listen, you have to keep an open mind throughout this trial. Until this trial is over, until you've heard the final arguments of the attorney, until the judge tells you the law that you have to apply, you've sworn an oath not to make a decision. And then I give them an example. I'll say, if it was your son or your husband was on trial in this case, and at the end of the state's case, you saw as the jurors walked out for lunch that day, you heard one of them say, I don't need to hear anything more. You know, I know how I feel about this. How would you feel that jury made up their mind in the middle of the case before you had a chance to present your witnesses, before you had a chance to present your closing arguments, before you had a chance to point out the frailties and the fallacies and the untruths in the state's case? How would you feel if your husband or brother was getting shortchanged by a jury that made up their mind halfway through the trial? That's why you have to keep an open mind. And oftentimes I'll lay little Easter eggs in there. I'll say, listen, during the course of this trial, you'll hear X testify. Listen very carefully. Mr. X was there. Mr. X saw the man who did this. And when the prosecutor asks him, can you identify this man? See what he says. We'll see what he says when he testifies, but listen very carefully to what he says. Obviously, I only say that if I know that that person has trouble making an identification or misidentified somebody or defined or told the police on the day in question that the defendant was 6'1", when in fact my client is 5'9". So I just tell him, listen very carefully. The state has to prove who committed this offense. If an offense was committed, listen to him describe the man who committed this offense. So, Joe, one of the things I'm hearing from you, these are all very general topics, very short on specifics, because I guess you don't want to be in a situation where you've written a check that you can't cash. And by that I mean you said that you're going, like for example, young attorneys, and my client is going to testify, and then of course at the end of the trial they don't testify, and the jury's saying, where's that testimony we were supposed to have? But the point I'm trying to make is, what I sense from you is that you're not going to make any representations on specifics that you're not 100% sure you're going to be able to back up. I've been in too many trials where the trial turned out to be completely different than what the prosecutor and I collectively thought it was going to be. Right. Facts are markedly different, and I don't want to tie myself down to one defense and make admissions as to other things when they, in fact, may not be able to prove those things that I would have otherwise admitted that I know to be true, but unless they bring the evidence in, and those witnesses either don't appear or they decide at the last minute they're going to say something different, I want to be free to take advantage of that change. So, and I can see you putting yourself in a situation where if you promised a jury A, B, C, X, Y, Z, and it didn't happen during the course of the trial for whatever reason, see the prosecutor stand up in summation and said, remember Mr. Rem told you in his opening you were going to have X, Y, Z, A, B, C? We're still waiting, and the proofs are over at this point. Don't ever write a check with your mouth that you may not be able to cash. Right. Okay. Now, over and above that, though, Joe, do you prepare them sometimes, especially when you have credibility case issues coming up, and you know that? And would you say to them, you're going to have to decide who's telling the truth and who's not? This is especially helpful when you don't have any case to put on. And you say, listen to their tone of voice, watch their body language, listen to, does their story make any sense? Pay attention to them, look at them. Do you talk to the jurors about gauging credibility, or do you say, just rely on your own common sense? How do you handle that? Well, what I do is I tell them this. When I begin that kind of discussion with an opening line, I said, listen, No one asked you to leave your common sense at the courtroom door when you walked in here. We asked you to bring it with you into that jury box and sit and use that jury. I said, use your common sense. I said, you notice we don't have 12 robots here. We don't have computers deciding this case. People think computers are so smart. Computers are so logical. Computers can think so quickly and reach conclusions. We don't have that. You know why? Because we have 12 people in this box who have a lifetime of experience in deciding whether someone is telling them the truth. How do they decide that? They listen to what the person says. Sometimes what they say is just incredible. Or maybe what they said sounded believable, but then you realize that they had a motivation for saying that as opposed to saying something else. It was in their own best interest to say that, and you wonder, I wonder if they were really telling me the truth, since they have a lot to gain by giving this other version. Or maybe they won't have a motivation that's obvious. Maybe they'll be telling you things that could make sense, but you watch them, the way they look down, the way they look to the side, the way they don't answer questions directly, the way they avoid direct questions from me, and you'll say, there's something hanky going on here. There's something hinky. I don't know what it is. I don't trust that witness. Maybe you'll have none of those reactions, but leave yourself open to that. We did not bring computers in here for a reason. We brought people in. There's 14 of you in this box. Let's say your average age between everyone is 40. 14 times 4, do you know we have 600-700 years worth of human experience? We brought you in here because we want those hundreds of years of human experience in judging the credibility of people and whether all of those inferences and facts, whatever they may be, amount to proof, not just proof by more than 50%, not just proof that's pretty substantial, but proof that's beyond a single reasonable doubt.
Well, then I guess the next question is logically, though, Joe, are you trying, when you try a case, are you trying it to individual jurors specifically, or are you trying it to the panel? And I want to kind of make my question a little bit broader. I mean, in other words, you detect that juror 3 is going to be a leader in the jury room, or you feel that juror 5, there's no way this person's ever going to vote to convict your guy. In other words, do you want the jurors to come to individual verdicts, or do you want to urge them to come to a collective verdict?
Well, certainly a prosecutor needs 12 to convict, and a defense attorney only needs 1 to have them walk out of that courtroom without a conviction. So,
would you say that to them? Would you suggest to them?
Oh, no, I wouldn't say that to them. I really wouldn't. Although,
why?
Because I think that would be usurping the trial function, and I think a judge would jump on me for that. I think a judge would come out and tell the jury to ignore that. They just have to. I can't guide them in their deliberations. I can't tell them that 1 can hang a jury. I think that I would run the risk that a judge would angrily scold me and might affect my reputation with the jury, and they might not trust me anymore. So no, I would never say that. But nonetheless, I do try the case to 12 different people, one at a time. There are times during my opening and summations where I will be looking at a particular juror for 30 seconds and speaking to that one. I know the others can hear me, but I speak to that one, and then later on I'll speak to another in the back row. And sometimes when I'm asking questions, I'll look over at a particular jury, a different one. So they all feel a personal connection with me. I believe strongly that you never have a podium in front of you when you speak to a jury in opening or summation, because it is a barrier. Yes, it's not a wall that's impervious, but it is a physical barrier, and the jury will feel that you're removed and you're aloof. A podium means you're preaching as a minister, or perhaps you're a professor giving a lecture. You need to have a conversation with those jurors as if they're your best friends, and that podium gets in the way. I think you should stand 3 feet from a jury box that's close enough so that they feel that there's an intimate conversation going on, but not so close. In America, 3 feet is what we call our personal zone. When people get closer than 3 feet, we feel uneasy. 3 feet is the perfect way to address them. When I address the jury in my opening, what I do is, before I speak, I get there and I stop and I pause, so that no matter what they're thinking and doing, their attention's drawn to me because I'm in front of them and I'm not speaking. This only goes on for 2 or 3 seconds at most. And I want them to see I'm gathering my thoughts because I have something important to say. And when that 2 or 3 second pause brings everyone to think what he's going to say next is going to be important. And I'll raise my arms in a 45-degree angle on either side so that my one hand is pointing to the furthest juror on my left, juror number 1 and juror number 8, to the right to juror number 7 and juror number 14. And I embrace them. I say, when you walked into this courtroom, and then I go on from there, so that I'm embracing. They all feel that physical embrace. They're all in the penumbra of what, and my eyes will scan all of them during that time. So we start to get this relationship.
is there a central mission, goal that you or any other defense attorney should seek to accomplish during the opening statement? Is it more educational, or is it attacking the state's case right off the bat, or and again, I'm just throwing these ideas out there. What is your strategic goal? What do you want to accomplish?
I never believe in attacking the state's case, and I'll tell you why. I have a deep and abiding belief. This may just be me, and I understand that, but this is my deep and abiding belief that anything I say will be taken with caution and circumspection by that jury. They don't know me. They're going to say, yeah, that's what he says. He's a defense attorney. I don't like to tell them things because they're going to fold their arms and say, really? Let me see that. What I like to do is plant the seeds in my opening and then watch them grow at trial. When testimony I know is going to come out will pop up, and they'll begin to think, and remember, I'm not going to talk about it. I'm just going to ask them rhetorical questions in my opening. Now they have to, they're going to have to prove if an offense was committed. But they have to prove if it was committed, who committed it. Let's see, is there going to be an identification in the courtroom? Of course there's going to be an identification, and you'll never forget a man that robbed you, right? You're going to hear the person that was the victim. He's going to describe the person that robbed him. When you know that the identification is going to be initially greatly in error, and you do that with other facts, you lay the seed, you don't tell them what's going to happen. Then when the witness says it for the first time, the jurors who are prepped to listen carefully say, wait a minute, subconsciously, Mr. Remy asked us to listen, but that doesn't prove the state's case. That's just the opposite. It has to come from within them. The jurors have to solve this case. I can only drop clues down a path, so like little seeds, and let them follow it. But I always let the answers to all the big questions in the trials arise from them. So they're thinking, wow, that attorney didn't realize it, but we discovered what the truth is here. We now understand it. So when it comes from them, when it arises within them, that's their decision, and they feel very strongly about it. They fold their arms. We solved this case. I'm very happy to be the humble man who just stumbled along and gave them these little bits of corn, and they were able to turn it into a complete story of what it is. It has to rise from within them, and I let them answer all the major questions.
So for the young attorneys in our viewing audience, then, if you had to say, this is what I want to accomplish in my opening in 3 words, what would you say it would be?
Lay the groundwork. Mm-hmm. Lay the groundwork, not factually, lay the groundwork that this is an unfair process, and as to how he was brought here, and that at the end of this, you're going to find out that with the way the court will instruct them on this case, they have to have no doubt whatsoever, and there's nothing in human history that has been free from doubt. And plant those seeds and let them feel that doubt, and then at the end, in your summation, you'll remind them, if you have a doubt, and that doubt's not unreasonable. That's what we would call a reasonable doubt. Even if you think he might be guilty, you have to say not guilty. Even if you think he's probably guilty, you have to say not guilty. Even if you think he's almost certainly guilty, all I have is one little doubt. Other than that, he's almost certainly guilty. You have to come out and say, Your Honor, we find him not guilty.
Joe, I want to take one little quick detour here and talk about jury selection, all right? Because I think it's intimately bound up with the idea of what you're going to put in your opening. Are you a believer in the use of experts?
Well, the answer is I have only used an expert on one case. Mm-hmm. And
how much time did your guy get?
it turned out to be a 7-year battle from the time he was charged until the time we ended the case. It was 7 years long, and it was a very difficult case involving ostensibly a conviction, 3 eyewitness victims, and strong circumstantial evidence. And to make a long story short, ultimately he prevailed on everything and walked away from 28 counts of an indictment with 3 different alleged victims. So in my opinion, now we had a jury consultant on that, and we went through a mock trial in front of fake jurors, and they listened to it and gave us their impression of how our client did when he testified, okay? And our client did not testify at trial, but we wanted to know how would he do, and how our other witnesses did, and how they liked our one theory of the case. And they told us sometimes they hated some of our theories, and we got rid of them. So those mock jurors in mock trials are helpful. But I have to tell you, the one thing that I've learned about jury selection is that I know very little about jury selection. I can't tell you the number of cases where I knew that there was 1 or 2 jurors that were fully against me. They weren't buying anything I said. And after the trial, I found out that they were 100% in my corner. And I've had the opposite, where I knew that juror was against me, and was for me, and they turned out to be the leader of the opposition. I really have no idea. So here's the way I select jurors. In order for me to address the jurors with complete sincerity and confidence, I need to have jurors that I trust, that I feel that I'm relating to. Whether I am or not, I can't say, but that I feel that way. I pick jurors that I feel comfortable with. I look at them and I feel I can talk to this person. I heard them answer questions. I feel I relate to them. And if I'm comfortable with them, I will come across more comfortable in front of the jury as a whole, and I will seem more credible. And my credibility will sweep over my client.
But it sounds to me, Joey, that this is really instinct more than anything else. It's just a gut feeling you get about human beings.
Right. Well, listen, in my county, I certainly know certain locations of people who might have biases or prejudices against certain other people, and I'll try to exclude them. And certainly if you have people who are upper crust and people are down committing street crimes, they can't relate to them. You may have a defense, but this is a genuinely good person who's allegedly committed this crime. I think other people of that socioeconomic level might understand that they exist in the community, but people removed from that socioeconomic class might judge them by a broad brush and not do so.
Well, Joe, I know you've had cases where, for example, you would want, I think if you could have had a jury of 12 police officers, you would have gone for it, just because of the nature of the offense, and you want law-abiding or people who are, law enforcement is very important to them. And then you'd have others where you'd want people where law enforcement is not all that important to them. It's going to depend on the facts and the type of case and what the charges are. Do you agree?
Well, there's no question about it. It depends on the county in which you're trying the case. There's certain counties where they don't believe a word a cop says. And there's other counties that if the cop says it, that's more certain than anything written in the Bible, and they fully believe in the Bible. So you have to be careful. If you have police officers taking the stand, you have to be aware of who your audience is. Some buy them, and some don't believe a word they say.
Joe, the thing that I'm concerned about during your opening is not to tip off the prosecutor as to any tactical or strategic vision you have of the case or information you have. Is this something in the back of your mind?
That's why I keep such a generic opening.
Right.
The prosecutors that try cases against me frequently hear the same opening for the most part. And I do so because I don't want to give them a path. I don't want to give them a guidebook as to where I'm going so they can head me off. They can prep their witnesses before they hit the stand. Listen, he's going to ask you about X, Y, and Z. Make sure you're prepared on this. The generic opening gives the prosecutor no idea where I'm going. Mostly because since I have no idea where the witnesses will really wind up, I have no idea where I'm going. I'm going to pick up whatever fruits they drop along the way and try to gather them into a defense.
On the scale of 1 to 10, how important do you think opening statements are for defense attorneys?
Well, here's the crazy thing. People talk about 4 things in a trial. They talk about your opening and your summation, direct examination, and cross-examination.
Not a whole lot more.
and everybody says, oh my God, cross-examination must be so incredibly difficult. And in fact, cross-examination is one of the easiest parts of a trial. The most difficult part, in my mind, two most difficult parts are the part that people think are the easiest, but I think they make a huge difference, and I think they're the most difficult because you have to structure them carefully. The number one most difficult thing in a trial is to do a good direct. A good direct has to be clear, and if you do it right, and you stand out of sight of the jury when you ask the questions, it'll sound almost as if you're not speaking, that there's a mind connection and they can read your mind and they hear the witness talking. You need to remove yourself from the equation and you need to tell a story and just have that witness affirm your story as in direct examination. That's difficult to do, and to do a good direct is critical. Second most difficult part is the opening, because the opening you have to hit all the right points and throw in the right rhetorical questions, but do it all very subtly. Certainly, summation is the next to last easiest part. And then the easiest part is a good cross-examination. Once you understand the structure of cross-examination and you understand about inconsistencies and one of the strategies I use in cross-examination, everything is fairly easy. So it's complete opposite of what the public would think and lay people would think about a trial.
The reason I bring this up is there's an enormously talented attorney. He's a career public defender in our county. He's tried over 500 jury trials to verdict. Okay, whoa. Yeah, and
he might have had a trial or two.
He sure has, but his unshakable or invariable technique is he never gives an opening statement. He doesn't. He just doesn't believe in them and saves it all for summation, and he waives it every single time. Now, take a look at Rule 1:7-1. Under 171A, the prosecutor is required to give an opening statement. The defendant is not. And I'm just wondering whether or not, he must have learned something for 500 trials. Although I remember the late Bill Zarling tried a case against him once and told me that he thought the fact that he didn't give an opening statement was dispositive of why his client got found guilty. He thought it was tragic because he thought the defendant might be innocent, even though he had prosecuted the guy. I'm just wondering, would you ever consider doing that, not giving an opening?
Well, certainly on rare occasions, judges in municipal court will ask you whether you want to do openings, and extremely rare. And, the attorneys simply because sometimes it's important. It really is that you want to get an idea in front of a judge so that he'll look at the videotape more carefully or listen more carefully to one of your experts, and you explain to him in advance where the expert is going. But in a jury trial, I have to tell you, that is a ballsy thing to do. I have seen an attorney who was an extremely experienced prosecutor, a career prosecutor, 28 years as a prosecutor, in a case in which a cop saw the defendant coming out a window, literally carrying a pillowcase full of the items from the home, and arrested him. And the defendant had taken a stand at trial and said, no, he just went in there because he had to urinate, and the windows open, so he went in, and this bag was laying there, so he carried it out to see what was in it. And it was the worst story you ever heard. And he told the jury at the end, he said, ladies and gentlemen, this is time for closing statement, but you heard the evidence in this case. You heard the officer's testimony. If that didn't convince you of this defendant's guilt, nothing will. Thank you. He sat down, the jury found him not guilty. And that caused a real storm in the office when word got back that he basically waived summation and the defendant went free. So it's not because of the fear of criticism, but I would never give up a chance to sway a jury, no matter how infinitesimally small, in my favor.
Now, we've been talking about this in the context primarily of you as a defense attorney. Can you just spend a few moments think back to the 1950s when you were in the Passaic County Prosecutor's Office?
1850s.
Just kind of, was there a different strategic goal? Because remember, under 171A, you got to give an opening statement as prosecutor. What's your strategic vision when you're giving an opening statement as prosecutor?
Well, you know what
Can you remember back that far, by the way?
Damn kids, could you speak up? I had a tactic that I used back then, and I thought it was effective, but who knows, right? I would read to them the counts of the indictment, right. And I would emphasize as we got through it and say, the defendant did on the 4th day of July, 1976, enter and remain in a premises to which he was not otherwise entitled, and in violation of statute, burglary statute, and against the peace of the state and the dignity of same. And when I got to the end, and I would say, and against the peace of the state and the dignity of same. And I would emphasize that at the end of each one as I read it. And
that's the only time Passaic County has ever been associated with dignity, by the way.
Yes, or peace. It's a war zone, sadly, in the inner cities, but that's true across the country. But no, and I would try to emphasize that, God is on our side, and the power and the majesty of the law is on our side. We're the good guys. We're wearing the white hats. That's what I would emphasize through every chance I got when I was the prosecutor.
But did you lay out your case, though? Did you say, look, you're going to hear from Officer X, you're going to hear from Officer Y, he's going to tell you this, this, and this? Or did you do a generic opening as well when you were prosecutor?
Well, no, I did a cross between that. I would tell them, Officer Smith is going to come in here. Officer Smith was on duty that day. Officer Smith is going to tell you everything he saw. He's going to tell you he took fingerprints, and he's going to tell you what the results of all those tests were. And, Officer Jones is going to come in, and he's an expert in, DNA analysis. Not that we all had DNA, but we just didn't know there was such a thing at the time. But whatever the expertise is, Officer Jones will come in, he's an expert in gangs, and he's an expert in lotteries, that is, the illegal lottery, and he'll tell you what the things that were found in this defendant's bag meant, and how they are examples of money that's being taken by organized crime to fund organized criminal activities. And even though the amounts are small, everything that contributes to organized criminal activity is an offense against the state and is offensive. Things like that. So I would not go into detail. I just tell them what the role each witness is going to play.
Joe, when you were a prosecutor, this was many years before the Chief Justice Willents had occasion to write State versus Williams. But if you remember in the Williams case, notwithstanding the fact this is a capital case, the prosecutor began her opening statement talking about the victim and how beautiful she was and how she had so much to live for and that she was in the church and she sang in the choir. And on the day before she was getting married, she was out with her mother looking for an apartment where she was going to be living after she got married, and they were going to go pick out her wedding gown, and just really extolling the virtues of this individual, and then saying that the defendant took this away from her in a horrible moment, an unspeakable moment of torture and things like that. In other words, a real emotional appeal to the jury, notwithstanding the fact that it all may be true. Is it more prejudicial than probative? Does it prejudice the defendant's right to a fair trial? And I was just wondering if you ever had that come up in your experience as a prosecutor, and people that you really, defendants that really need to be punished.
Yeah, it certainly as a prosecutor, I eschewed that. I was strongly against that. Prostitutes had the right not to be raped, and good people didn't need to be good people not to be the victims of violence. And I did not go near that. First of all, I do think it's unduly prejudicial. I do think it's wrong. I think the defendant's not getting a fair trial. And way more important than any verdict is the process. The only thing we can ensure is the process. That's what justice is. People think justice is a result. It's not. It's a fair process. That's what justice is. Only in the afterlife, if there is one, will you know whether someone was truly innocent or guilty. The best we can give them on the face of the earth during our lives is a fair process, a fair trial. That's what I sought to achieve, and I would never, ever resort to talking about how good and wonderful the victim was, because that's irrelevant. I wanted to show that the defendant committed a crime. And I would point out details of the crime, which were terrible, but they were facts about how this crime was committed and were relevant to the innocent or guilt. So as a defense attorney, if a prosecutor ever went down that road, I would be all over it from the first moment, because my client has the right to have a fair trial. And to talk about the victim because they're sweet and kind, how does that change whether my client did this? And it's an attempt to persuade the jury. In the final jury instructions, the judge will tell you that you're not partisans. You're judges of the law, and you have to decide this impartially.
Judges of the facts.
Right, judges of the facts. I'm sorry, and they have.
But I'm going to talk about them being judges of the law in about a moment.
Right, you have to decide without passion or prejudice. And without emotion. You have to decide this on the facts and the law. And to allow someone to do that to me when I'm representing a client, well, I would be all over it right from the beginning and have the judge instruct the jury about it. But as a prosecutor, I never even attempted that. I was opposed to it.
Let's talk about this as jurors, as judges of the law for a second, okay? And of course, I'm referring to jury nullification. I can't imagine that you have not argued that in some way, shape, or form, walking the line, a very fine line, to keep yourself from getting jammed up. But either in your opening or your closing, how would you approach that issue?
Well, and I just
actually, may I just tell you just a quick thing? My partner he did this all the time because he knew what he could get away with, and he would stand up and he would say something like, "Oh, jurors, only you are the ones who can prevent my client from being convicted and getting 10 years in prison." Okay, and of course the state would always stand up and object. The judge would give, of course, their instruction, but the bell has been rung at that point.
So you were only asked to make such examination that might be useful to the prosecution, none that might help the defense.
I object, Your Honor. The question is argumentative. Counsel for the defense is trying to impugn the intent of the representatives of the people.
Mr. Beegler, you must be aware that the question is improper.
I withdraw the question, Your Honor, and apologize.
The question and answer will be stricken, and the jury will disregard both the question and the answer.
That's all the questions I have.
No redirect. The people now call Lloyd Burke.
Will the witness step forward, please?
How can a jury disregard what it's already heard?
You do solemnly swear the testimony you shall give in this cause shall be the truth.
Cautionary instruction notwithstanding. What are your thoughts about all this, Jeff?
Well, I certainly have only mentioned the penalty once in a trial, and only when the state's expert witness just opened the door wide open by talking about the fact that, the crime that, I won't go into detail, but he just simply said, well, this crime is, not that serious. Talking about my client, he said, not that serious. I said, My client could do 20 years in state prison. If she's convicted, she's looking at 20 years in state prison. You don't think that's serious?
State objected, of course.
State went berserk. And the judge listened to him, out of the presence of the jury, and listened to him. He said, your expert witness said it wasn't that serious. I think Mr. Rem had the right to say that 20 years, give them the facts and let them decide whether they think 20 years in state prison is serious. And he says, what do you think they're thinking about that? And no, that's the only time I had the opportunity, and I jumped on it. And my client, who actually was innocent, I know that she was innocent for a lot of reasons, but not the least of which is that the facts indicated she was innocent. The arresting officers told me privately they thought she was innocent. She passed the polygraph examination, and I actually gave the police the names and addresses of the people who were guilty. And they never pursued it, and that's what the expert was talking about. But we never pursued it because it's not that serious a crime. This was large-scale drug distribution of 1 kilo of cocaine. And they said, it's just not that important. That's why we didn't investigate the names and addresses. I said, the names and addresses we gave you 2 days after this offense. We gave you the names and addresses. And you checked, no, we didn't check out. You didn't check to learn that they had prior convictions for drug distribution? No, we didn't know that. So, I had the chance to do that in that one case, but other than that, no. But jury nullification is simple. You try to minimize, your client's involvement, so it's just on the borderline, and then try to show the jury through your statements that what the state is seeking to prohibit is something, and it's something far greater than what the facts suggest your client did. That's how I try to get jury nullification in there.
Sometimes, Joe, I see young attorneys, they have really no confidence and no experience level, and they'll be coming up with all kinds of notes and things like that. Sometimes they're reading stuff to the jury. I'm a big believer, go up there with nothing in your hands at all, except maybe like a little index card with a couple talking points on it, but that's it. What are your thoughts on that? Just as a training issue.
Well, a piece of paper might as well be a brick wall. It's a further barrier between you and the jury. And if they think that you're reading from this, they all just roll their eyes because they're tired of having people read to them or look down at a list. They want it to come from your heart. They want it to come from your soul. And you can't impart that kind of feeling if you're reading from it. And that paper blocks them out, the same as a brick wall, the same as a podium. I believe strongly, I tell young attorneys, I said, if you go up there without that piece of paper, you're only going to remember 90% of your points. You're going to forget 10%, and you're going to get back and hit yourself in the forehead. I said, why didn't I remember this? Why didn't I remember that? But the truth is, if you go up there with that piece of paper and you get 97% of your points, what you've lost in connecting with that jury is far greater than what you gained by making those 1 or 2 points.
Joey, this is, and I don't want to say this is troubling me, I just foresee in New Jersey jury trials a move in the future away from proofs, guilt, innocence based upon the levels of belief, moving toward a pure, objective guilt or innocence. And I think that's going to be enabled by the following things. Security cameras everywhere. You can't walk down the street without being videotaped somewhere somehow. The use of police body cameras, the police in-car video, cameras, cell phone cameras all over the place. And I just think that the public will expect it, and obviously prosecutors will rely upon it, and it could fundamentally change the entire way the criminal justice system is handled in the courtroom. What are your thoughts on that?
Well, certainly we know that for the last 10 and 12 years we've been living in the CIS world because of all of the TV shows talking about forensic science. Jurors expect forensic science in every case, including check-writing cases, when there really is nothing except maybe a handwriting expert. In a check-writing case, they expect that kind of dramatic evidence. The failure of the state to produce it is actually held against them, even though they have the same amount of visual testimony, that is, testimony of eyewitnesses and circumstantial evidence that jurors have had for hundreds of years. They're not satisfied with that now. Their level of expectation of what the prosecutor must produce is higher, and in many ways it makes it more difficult for the prosecutor. The good point about having cameras is, and how objective they are, is that anything that makes guilty people more likely to be convicted is good for society, and anything that makes innocent people more likely to be acquitted is good for society. So there's nothing bad about the objectivity of cameras, and it's more than what they record, it's what they deter. when you're wearing a camera or you know there's cameras around and you're a police officer, you're going to conduct yourself more professionally, be less likely to attack someone, less likely to antagonize them verbally. You're going to act more professional. So we're going to have more professional police conduct as a result of cameras.
Rapidly reaching the point where every human being, child up to old person, is going to be equipped with the ability to do video and audio and things of that nature, and there will be a plethora of every weird thing that happens is going to be on videotape.
When you remember Google Glass, the camera was built into the eyeglass, and now Google brought that product off the market since then, but you know that's coming back in some way. Cameras will be so miniaturized, people may be recording their entire daily life.
That's something I was going to message you, Joe. I see this advertised on television now. They have these video cameras that they're on the whole time. They're videotaping the inside of the car and also from the driver's perspective. So if you're in an accident, this is going to become standard equipment on every vehicle because it just makes common sense, But the trend, I think, long term is going to be toward objective justice as opposed to levels of belief. And that may fundamentally change the way that trials get done because it's certainly going to take a lot of ammunition away from the defense bar, wouldn't you think?
Yeah, because fewer innocent people will actually be taken to trial because an objective view of the videotape may suggest to the police or the prosecuting authorities there was no offense, or at least it wasn't this offender. So less innocent people will be charged, and it'll be more guilty people with more evidence against them. So from a defense attorney's point of view, that's not helpful.
Let's move over to talk about closing argument for a moment, Joe. Again, I don't want to overstate the obvious because what you're trying to do is get the jury to believe that the state's evidence is just about $3 short of proof beyond a reasonable doubt. But I would imagine your goal is to do exactly the opposite that you did in your opening. Whereas your opening was generic, your summation is going to be highly fact-specific. And are there things that you can do during the course of the trial that you know you're going to want the jury to remember, that you can do to kind of remind them during the trial? Objections you can raise or things of that nature, things you can do to kind of bookmark issues that come up during the course of the trial?
The answer is I do the opposite. I like for nothing to be important during the trial because then the prosecutor doesn't focus on it, and then I make them important at the end of the trial. Some of my most successful defenses have involved my asking generic questions, so generic and seemingly irrelevant that there were objections, what's the relevance of this? And having already gotten as far as I need to, I then walk myself back. And at the end of the trial, before we begin summations, this jury realizes that I presented no defense whatsoever. But then I start piecing together all these little tiny pieces of information, and they lockstep together, and all of a sudden the jury says, and I see the light go on, and they say, oh my God, this person must be guilty. I mean, I'll give you a small example. I had a case where a movie theater in Passaic County was robbed at gunpoint by two men, and one of them was wearing a ski cap. In fact, both of them were wearing a ski cap. And a ski cap was found in the defendant's car when he was stopped a few miles away leaving for the theater. We didn't have a positive ID of the defendant because the ski mask had, holes for a mouth and eyes, and so there was no identification. I was the prosecutor in that case. And so the defendant took the stand, and the defendant indicated that, why would he have the ski cap in his car? Well, he works in a body shop. And he said, and he wears it, on his head so his hair doesn't get full of the grease and the paint and everything. And so I started my cross-examination by trying to debunk that, seemingly trying to debunk that. I said, you mean to tell me that you don't have fans? Oh, no, there's dirt all over the place? Absolutely. The more I tried to prod him into saying it was a clean environment, the more he tried to make it dirty. Oh, we're spray painting cars, there's paint, there's oil, there's grease, there's everything throughout the shop. He says, and that's why I wear this, that's why I always wear this hat. Okay. And I sat down seemingly defeated because he had clearly pointed out that this was a filthy environment, and I hadn't succeeded in proving that it wasn't. And in summation, I said, ladies and gentlemen, you know how he's guilty? He says, this is the hat that he wore for months beforehand. It is crystal clean. It is a white top. It couldn't be purer or whiter than snow that's just fallen. Look in here. If you find the tiniest speck of dirt or a smudge, then you find him not guilty. And the jury came back and found him guilty based on that.
Joe, I know one of the things you try to do especially as a defense attorney, and you mentioned this earlier on, is about having the jury solve the mystery. In other words, it's really kind of related to not answering the last logical question during your cross-examination. Can you tell the story about the gun without the fingerprints?
Well,
I bring this up because it really kind of ties into the point you're trying to make before about the expectation of jurors in forensic evidence, that they really have unrealistically high expectations.
Well, it was a question of identification as to my client, and the victim said that my client was there, and this was his gun, and he pointed it at him, and my client probably didn't take the stand. So at the end of the case, I told the jury, I said, you heard what he said, but you've heard, that he has a criminal record and blah, 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 and he had reason to motivation to lie about my client and all those things, I said. And yet he said that my client held this gun and pointed at him. I said, if only there had been video cameras there, but there weren't. If only there was some way that there could be proof as to whether or not my client held that gun in his hand. If there's only some way, and I asked this rhetorical question and paused as seemingly as if I'm thinking about it, and one of the jurors from the back row yelled out, "Fingerprints!" Now, hoping if he hadn't said it, I would have come around to that in a second, but having him shout that out. Now, what I had to do carefully is I can't talk to jurors, so I couldn't respond to that, and I certainly didn't want anything in the transcript. So what I did is when he said that and he shouted that out, and I turned to him and I just pointed at him. So that never made it into a transcript. Remember, there's no cameras back in those days. And I pointed at him like, right on. And then he was sat there glowing and beaming. He was so proud. He solved his case. There were no fingerprints on that gun, no evidence as to my clients having held that gun. And I knew he was going to go in there and trumpet that to the other jurors, and they were all going to feel, yeah, that attorney, he didn't even think about that. We thought of it. We were the ones that got his client acquitted. He never thought about that. I'm very happy to be humble and let the jury save my client from my own ineptitude.
I want the young attorneys who are watching this to think about this psychologically. When a juror thinks that he or she has solved the mystery, they become very, very, very wedded to that opinion. And it's very hard to move them off of that if they figured it out themselves. And if you have 2 or 3 or 4 who've all come to the same conclusion simultaneously, you've got a shot, whichever way you're going.
Which is why, in summation, I'll never use the word not guilty. I'll simply say, look, if you believe the state's proven their evidence, if you believed after everything you've heard that they proved it, and they proved it beyond a reasonable doubt, you have no doubts whatsoever, I said, then you have to find my client guilty. But you've heard the evidence, you heard about the motivation, you heard about the missing witnesses, you saw the lack of DNA evidence, the lack of forensic evidence. If you take all that into account and you put it together, when you go into the jury room, I suggest that you're going to deliberate and you're all going to agree on what the verdict is. And right now, you all know what that verdict will be. Thank you. And I don't say not guilty. I lead them to the point and I pause. I say, and you know what that verdict will be? Yes, you do. And then I walk away and I never say the words not guilty, because as I'm pausing and saying, oh, he's going to say not guilty, not guilty. And the word not guilty, they're running it through their own mind. So I never say it. They reach that conclusion, not me.
So, in one just tactical issue, Joe, I know that you're going to have certain things you're going to want to point out during the course of the summation. All right, and these will be hard facts or pieces of testimony or evidence, things of that nature. During the course of either listening to the state's evidence or during your summation, during your cross-examination of the state's case, do you give yourself little talking points to say, okay, now I'm going to want to talk about this, I'm going to want to talk about this, I want to make sure I mention this during summation. So you have kind of an inventory. So when you're getting yourself ready, you have things you can rely on? Or do you just go from your own memory?
Never from my memory. Never. I mean, I organize it, I structure it, because the facts aren't important by themselves. It's how they weave into your story. So you have to come up with your story, which is just a logical progression of how you're going to present these facts, so they keep building on each other to a higher and higher effect, reaching a crescendo at the end. So it's about structure as much as it is anything, because structure begets persuasion, and it's about persuasion. So yes, I outline it, I detail it, I come up with my connectors.
But you're doing this in real time, though. Is what the point I'm trying to make is during the course of the trial. If you make a point on cross-examination, don't you want to make some type of notation somewhere saying?
I put a little tiny star to the left of my notes. Remember this for summation, little tiny star.
Right.
So then I go collect all my little tiny stars, put them logically, think about it, and then, so my summation should always look like it came off the top of my head, like I'm relaxed, I'm just thinking about this for the first time, but I'm not. This is a lot of thought has gone into this.
And this is the point I'm trying to make, is that there is an enormous important relationship logically between a cross-examination and a summation, because many times your summation is going to relate to information that was brought out on the cross. And if you make good points, you've impeached somebody or come close to impeaching somebody, or be able to just demonstrate a reasonable doubt about maybe their perception. It may not be a question of credibility, but perception sometimes.
It's critical to say that the officer did a great job, but he did not know this. Or he did a great job, but he wasn't taught to do one further step, which would have exonerated my client. So never fault the police officer. Say it was beyond his control to come to the correct conclusion when he charged my client. He just didn't know certain things. It's no fault of his. He's an excellent police officer, and the people in his community are lucky to have him. Had he only known this, that good police officer might have reached a different conclusion. You know it. He didn't. You're in a much better position to make a decision.
And one other thing, too, Joe, I want the young attorneys to kind of understand is human beings from a Stone Age, in fact, caveman times, people sitting around the fire, glazing up the stars and wondering what all that was over and above them. When they sat around in these very small hunter-gatherer groups, they entertained themselves by telling stories in whatever primitive language they spoke in those days. This is how human beings, this is in our DNA, so to speak, as human beings. This is how we respond to this. Just the same way that human beings respond to the exchange of food, one person handing a piece of food to another. That's a bonding technique. And I think you kind of got to get into the jury's DNA by telling them a story and structuring the story, especially in your closing. You have any thoughts on that, Joe?
I believe that because jurors will gladly follow a story that they don't know the end to. And if they're being led down with mystery and intrigue and enlightenment, it's like reading a novel. And they'll follow you gladly. If you just start sprouting facts, we heard that fact, and you don't tie them together, and one fact doesn't enhance the next one, by themselves, these facts are really useless. It's when they're woven together that they form the persuasion that you need, and you do that through the storytelling.
But do you want them to write the last chapter? Solve the mystery?
I want to bring them to the last page, give them all the clues as to what's on that last page, let them turn it in the jury room by themselves.
3 words, strategic goal for closing argument, Joey.
Get out alive.
Joseph P. Rem Jr. This has been wonderful and extremely instructive for the young attorneys, and I thank you so much.
Thank you, Mr. Ramsey.